Have you ever imagined yourself standing in front of your dream home, keys in hand, ready to step inside? It's a powerful image, isn't it?
Oh, definitely. It's the goal for so many people.
But have you ever paused to wonder what truly goes on behind the scenes to make that moment possible? Beyond the open houses and signed papers lies an incredibly intricate world of legal definitions, financial intricacies, and crucial relationships that shape every single real estate deal.
Mm,
From the outside looking in, it can seem like a dense, almost impenetrable jungle.
it absolutely can. And that perceived complexity is precisely why understanding the foundational elements of real estate is so vital for anyone. Whether you're a first-time homebuyer, a seasoned investor, or just someone looking to understand one of the biggest economic forces in our lives, this deep dive is for you.
Exactly. Today, we're embarking on a deep dive into the foundational principles of California real estate. Our mission isn't just to explain what happens, it's to cut through the jargon, illuminate the surprising facts, and distill the essential knowledge you need to grasp the core concepts of this dynamic field. Whether you're curious about different types of property ownership, navigating agency relationships, or just want to understand how real estate transactions actually work, we've got you covered.
And we've pulled insights from extensive, expert-written study guides designed to prepare people for the rigorous California real estate exams. So think of this as getting the ultimate shortcut to being well-informed on these complex topics.
Yeah, equipping you with the knowledge to make smarter decisions and feel more confident in any real estate interaction.
Exactly.
So let's begin our journey of decoding your biggest investment, starting with the very heart of the industry itself, the real estate profession.
Well,
The real estate profession. Beyond just buying and selling. When most of us think of real estate, our minds immediately go to buying or selling a house, right? We picture agents showing homes, maybe listing properties online.
sure, that's the most visible part.
But what our sources immediately reveal is a much broader, more diverse landscape of activities that fall under the real estate umbrella. It's far more than just a sales job.
It's true. What's often overlooked is just how truly expansive and multifaceted the real estate business is. It's not simply about sales. It encompasses a wide spectrum of activities, all operating under the umbrella of brokerage.
Okay.
These diverse activities are precisely what make the field so dynamic and offer so many specialized avenues for professionals. Beyond the visible act of showing and selling a property, the real estate business deeply involves sales and leasing, which is what most people picture. But it also extends to counseling clients and customers, offering expert advice on various real estate matters.
Okay. Like advising on investments.
Could be, or market trends, things like that. Then there's property management, where professionals oversee and maintain properties on behalf of owners, ensuring profitability and upkeep. Furthermore, the critical area of value and financing includes everything from appraisals to navigating the complex world of mortgages and loans.
Right.
And finally, real estate also extends into development and construction, from acquiring raw land to subdividing it and building entirely new structures. It's really quite vast.
You just mentioned specialization, and that's where it gets truly interesting. Our sources really highlight that a real estate salesperson can dramatically expand their opportunities by narrowing their focus and gaining niche knowledge. For you, the consumer, it means there are highly specialized experts out there for almost any need. This isn't a one-size-fits-all industry, is it?
Not at all. Specialization allows agents to become genuine experts, deeply knowledgeable in a particular segment of the market. This raises a crucial question. How does an agent find their unique corner in such a vast field? And more importantly, how does that specialization benefit you?
Right.
Our sources outline several methods. For instance, an agent can specialize by client, choosing to work exclusively with buyers or sellers. Imagine a residential seller's agent who focuses specifically on handling short sales. Those are properties selling for less than the mortgage owed.
Oh, that's complex.
Yeah, that's a very targeted, intricate niche that requires deep expertise.
So it's not just who they work for, but what kind of property they deal with.
Exactly. Specialization by property type is a huge one. You have agents who focus solely on residential properties like houses, townhouses, or condos. But then there are those who specialize in commercial properties, which include office buildings, retail complexes, gas stations, or entertainment venues, essentially. Properties designed to generate revenue.
Okay.
Industrial properties like manufacturing plants, warehouses, or data centers are another distinct type. Agricultural properties such as farms, ranches, and orchards form yet another specialized area. And don't forget special purpose properties, which are built with a specific limited use in mind. such as churches, schools, or recreational facilities.
Wow, okay. That makes perfect sense. So beyond the type of property, how else might an agent carve out their niche?
Agents can also specialize by type of transaction. This could mean becoming an expert leasing agent or an REO, real estate-owned specialist, someone who handles properties acquired by lenders through foreclosure.
Which has its own whole set of rules, I bet.
Absolutely. Unique legal and financial complexities. Or a professional property manager focusing on the day-to-day operations of rental properties. Another highly effective method, often referred to in the industry as farming, is specializing by geographical area.
Farming, like agriculture.
Sort of, but for neighborhoods. It involves an agent becoming an absolute expert in a focused neighborhood or community, understanding its unique market dynamics, property values, and community features. This allows them to cater their marketing efforts with pinpoint accuracy, truly becoming the expert for that specific area.
So when you see a realtor's face on every bus bench in your town, they're probably farming that area.
Precisely. And finally, specialization can also occur by relationship type, meaning whether an agent operates as a fee-based consultant, a traditional commission-based agent, or even a full-time salaried employee for a large brokerage or corporation. Often the most successful agents will combine several of these specializations. For instance, a residential buyer's agent who specializes in a particular historic neighborhood.
The core insight here is that the real estate profession offers an incredible depth of expertise. As a buyer or seller, knowing these specializations exist means you can find an agent uniquely qualified for your specific needs, which can make all the difference.
Definitely.
But whether you're working with a highly specialized agent or just trying to make sense of what you see out there, it all comes back to understanding the market itself. The market dynamics dictate so much.
That's spot on. If we connect this to the bigger picture, the housing market is fundamentally driven by the simple, universal economic principle of supply and demand.
Basic economics.
Right. This dynamic constantly shifts, impacting whether it's a buyer's market or a seller's market. Understanding this basic concept is key to navigating any real estate transaction, whether you're buying a simple condo or a commercial empire. In a seller's market, you typically see few houses for sale, but many eager buyers.
High demand, low supply.
Exactly. This means demand significantly outstrips supply, leading to multiple offers, bidding wars, and generally higher prices. Sellers definitely have the upper hand here.
So if you're a buyer in that scenario, you're often feeling pressured and perhaps overpaying. It's tough.
Exactly. Conversely, a buyer's market is characterized by many houses for sale, but fewer potential buyers. In this scenario, supply exceeds demand, giving buyers more leverage.
More choices, less competition.
Right. They have more options, can take more time to decide, and may be able to negotiate more favorable terms, including price. The key takeaway for you is that these market conditions are fluid. They can change from month to month or year to year, even within specific neighborhoods, underscoring the importance of working with an agent who truly knows the market you're in.
Yeah.
Their insight into this supply and demand balance can literally save or make you thousands.
This all brings us back to brokerage. We hear that term all the time, but what exactly is a brokerage beyond just the physical office or the individuals working there? What's its foundational purpose in the real estate world?
That's a great question, because brokerage is essentially the engine that drives every real estate deal. It's the business of overseeing, consummating, and completing real estate transactions by bringing parties together.
It's an intermediary.
Pretty much. A broker is the person who runs that brokerage, holding the primary license and legal liability for the actions of anyone operating under their umbrella, including salespersons and broker associates. The duties of a brokerage, carried out through the broker and their team, extend across those diverse areas we just mentioned: sales, leasing, counseling, property management, and even development.
Okay.
But at its heart, a brokerage fulfills these duties through two core continuous activities: constant searching for new people to work with, whether those are sellers, buyers, or other third parties, and perpetual problem solving to get a transaction to closing.
Always putting out fires, probably.
Sometimes feels like it.
Yeah.
The core insight is that a brokerage is a proactive problem-solving hub designed to navigate the complexities of real estate on your behalf.
Yeah.
2. Navigating property ownership. Diverse forms and structures.
Let's shift gears and unpack a really fundamental distinction that often tricks people up when they're new to real estate. Real property versus personal property. It sounds simple, but it's much more than just what's attached to the house. It has significant legal implications for what you actually own and what stays or goes in a sale.
This is a crucial starting point because it dictates what precisely you're acquiring when you buy real estate. Real property includes the land itself, all its improvements,
Hmm.
that is, permanently attached non-natural structures like buildings, fences, or roads.
Things you can't just pick up and move.
Exactly.
Mm.
And the associated bundle of rights of ownership, which are rights a homeowner automatically receives with the title, such as the right to possess, control, enjoy, exclude, and dispose of the property. These improvements must be permanently affixed to the land, meaning they're not easily removed without damaging the property.
So if I buy a house, the built-in cabinets are real property, but my freestanding fridge is personal property.
It's exactly right. Personal property, conversely, is anything unattached and movable, like your furniture, that freestanding refrigerator, or even a car. It typically goes with the seller in a sale unless specifically outlined and agreed upon in the sales contract.
Ah, okay. So always check the contract for things like appliances.
Definitely. For example, a chandelier that is permanently wired into the ceiling is usually considered real property, but a portable lamp is personal property.
That distinction makes sense for most things, but what about something that seems a bit ambiguous, like a mobile home or a manufactured home? Our sources even bring this up as a special case.
That's a perfect illustrative example of where it gets tricky, because even manufactured or mobile homes, though inherently movable, can become real property.
How does it work?
This happens if they are permanently installed on a foundation system and meet other specific legal requirements, essentially becoming a permanent part of the land. If they don't meet these criteria, they remain personal property.
Interesting.
The core takeaway here is that when you purchase real property, you're not just buying a physical structure, you're acquiring a complex set of rights that comes with permanently attached items and the land itself.
So once we've nailed down that fundamental distinction, let's talk about ownership that gets a bit more shared and complex common interest properties like condominiums or timeshares. These are becoming more and more popular as lifestyles evolve and land gets scarcer, especially in California.
Right, you see a lot of these. What's truly fascinating here is the blend of individual and shared ownership that defines these types of properties. These structures are designed to manage shared amenities and community living, often under specific legal frameworks.
Like HOAs, homeowner associations.
Exactly. In California, a prime example is the Davis-Sterling Common Interest Development Act. Think of this act as the rulebook that creates financial safeguards, disclosures, and protections for residents of community associations. This act covers everything from condominiums and co-ops to planned unit developments, or PUDs.
So how does that individual and shared ownership actually work in practice? How is it divided?
Let's break it down. In condominiums, owners have a separate interest in their individual unit, like the interior of their apartment, the walls, floors, and ceiling within their specific living space.
Your private space.
Right. But, crucially, they also have an undivided interest in the common areas. These common elements are portions of the shared ownership property not controlled by any one owner. They can include parking lots, lobbies, fitness centers, elevators, swimming pools, and even the exterior structure of the building.
So you own your box, but you share the playground.
Kind of, yeah. This means that while you own your specific living space, you share ownership and financial responsibility for the broader community facilities and their maintenance, usually through those HOA dues.
And PUDs, or planned unit developments, are a bit different, right? They often sound like master planned communities.
Yes. Planned unit developments, PUDs, are indeed another type of common interest ownership, often found at larger subdivisions that can feel like self-contained communities. Unlike condos, PUDs typically involve individual lot ownership, along with shared recreational facilities that are co-owned by the lot owners as tenants in common.
So you own the land under your house too, usually.
Typically, yes. What's truly unique about PUDs is that they can often depart from normal zoning and subdivision regulations, allowing for a mix of residential and non-residential real estate, and often more flexible designs within the development. Think of it as a neighborhood designed with a big park, a community pool, or even a small shopping area, where everyone shares in the common amenities.
And then there are timeshares, which seem to have their own unique set of rules and sometimes a bit of a tricky reputation.
Timeshares are certainly distinct. They are a form of co-ownership, where each owner has the right to use the property during a different prescribed period of time, essentially sharing occupancy throughout the year. It's like having a slice of the calendar for a vacation property.
Gotcha. Week 27 is mine.
Something like that. In California, the California Timeshare Act of 2004 heavily regulates timeshare sales. This act is crucial for consumer protection. It requires developers to provide a comprehensive public report to prospective buyers before selling a timeshare,
So you know exactly what you're buying.
hopefully. Furthermore, buyers must sign a receipt acknowledging its delivery, ensuring they have access to all the necessary information about the property, its costs, and the rules. A critical protection under this act is the 7-day right of rescission.
A cooling off period.
Exactly. This means buyers have a legal right to cancel their purchase agreement for any reason within 7 calendar days after signing the agreement or receiving the public report, whichever occurs later. This provides a crucial safety net for such a significant commitment.
That's good to know.
The core insight for common interest properties is understanding the dual nature of ownership, individual space, and shared responsibility, all governed by specific rules and regulations that protect community living.
So once you've picked your property type, whether it's a single-family home or a condo, how do you actually hold it? Our sources outline 3 basic forms of ownership, each with distinct implications for control, inheritance, and even potential liability. This is where it gets really important for personal and estate planning.
The choice of ownership form has significant legal and financial consequences, particularly regarding control, inheritance, and liability. If we connect this to the bigger picture, it's about how rights and responsibilities are allocated among owners, both during their lifetime and after death. The 3 basic forms are ownership in severalty, co-ownership, and ownership in trust.
Let's start with severalty. It sounds like it means sole.
It does. Ownership in severalty is individual or sole ownership, where one person or entity holds an exclusive interest in the property. They have complete control over the property, can sell it, mortgage it, or do almost anything with it, as long as it's legal.
Simple enough.
Right. Upon their death, the property typically passes to their heirs through a will or the probate process. It's the simplest form of ownership, with clear lines of control.
And co-ownership is where it gets more complicated, with different rules depending on the type, especially when it comes to what happens when someone passes away.
Exactly. Co-ownership, also known as concurrent ownership, is shared ownership with another person or entity. Within co-ownership, there are a few key concepts. First, undivided interest means each co-owner has the right to possess the entire property, not just a physically divided portion of it.
So you can't put tape down the middle of the living room.
Pretty much, yeah.
Yeah.
Imagine 2 friends owning a house together. Neither one can say, you only get to use the living room. They both have access to the whole house. Second, right of survivorship is a crucial statutory principle. When one co-owner dies, their ownership interest automatically reverts to the surviving co-owners, bypassing their heirs.
So it doesn't go into their will necessarily.
Correct. Without this right, the interest goes to the deceased owner's heirs, which is called the right of inheritance. This distinction dramatically impacts estate planning. Now, let's look at the specific types of co-ownership. Tenancy in common is the most common form for unmarried co-owners. It includes that undivided interest we just talked about, but it comes with a right of inheritance, meaning there's no automatic survivorship.
So if my friend and I own a house this way and they pass away, their share goes to their kids or whoever's in their will.
Exactly. Their share goes to their heirs, not automatically to you. And importantly, it allows for unequal shares of the property. For example, 2 friends could own a property as a tenant in common, with one holding 70% and the other 30% of the financial interest.
That's flexible. So joint tenancy must be the one with survivorship then, and stricter rules.
You're absolutely right. Joint tenancy usually includes the right of survivorship, which is its hallmark. It also requires what are known as the 4 unities to be present at the moment the property is acquired.
4 unities. Sounds formal.
It is a bit. They are. 1. Unity of possession. Every owner can use all of the property. 2. Unity of interest. Each co-owner must own an equal share of the property. 3. Unity of time. All co-owners must have purchased the property at the same time. 4. Unity of title. All co-owners must have purchased the property with the same document, like a single deed or will.
Okay, so equal shares, same time, same document, full access.
You got it. If any of these unities are broken after the creation of the joint tenancy, for example, if one joint tenant sells their share to a third party, the joint tenancy may convert to a tenancy in common for that specific share, losing the right of survivorship.
Oh, interesting.
The core insight here is that joint tenancy is designed for automatic, seamless transfer to survivors, but it demands strict equality and ownership from the outset.
And for married couples in California, there's a unique system, isn't there, tied to our state's legal framework?
Absolutely. Married couples in California fall under a specific framework because California is a community property state.
Right, I've heard that term.
This means property acquired during marriage, with a few exceptions like gifts or inheritances, is considered equally owned by both spouses. This means neither spouse can sell or encumber community property without the signature of the other. This concept also explicitly applies to registered domestic partners.
So decisions about community property have to be joint decisions.
That's the essence of it. There's also the related concept of quasi-community property, which is property that would have been community property if the acquiring spouse had been domiciled in California at the time of acquisition, even if it was acquired elsewhere.
So if you move here from another state.
Exactly. This is particularly important for couples moving into California, ensuring fairness in asset division. The key takeaway for married couples is that nearly everything acquired during marriage is presumed to be equally shared, with major implications for control and disposition.
And the final form, ownership and trust, seems like a more formal, almost strategic way to manage assets, especially for long-term planning.
It is. Ownership and trust involves a legal entity where a truster, the creator of the trust, transfers control of assets to a trustee to be held and managed for the benefit of a beneficiary.
Like setting up a trust fund, basically.
Similar concept, yeah. This structure offers significant flexibility in managing and distributing assets, often bypassing probate and offering privacy. There are several types. Living trusts are created while the truster is alive and can be either revocable, meaning they can be changed after formation, or irrevocable, cannot be changed once established.
Revocable seems more flexible.
It is, but irrevocable offers different protections, sometimes for tax or asset protection reasons. Testamentary trusts come into being only upon the truster's death, and unlike living trusts, do not prevent assets from going through probate. And land trusts are specialized trusts, where land is held by a trust for long periods, which could be used to avoid liens, hide the true owner of a parcel of land, or simplify transferring land as part of a will. Each type serves different purposes in estate planning and asset management, but the core insight is that a trust allows you to control your assets even after you're gone, often with greater privacy and less red tape.
For larger, more complex real estate ventures, individuals often pool their resources into specific legal structures. It's a way to tackle projects that would be impossible alone, bringing together significant capital and diverse expertise.
Right, like building a shopping mall or a huge apartment complex. This raises an important question about how sophisticated investors structure their real estate ventures to manage risk and maximize returns. Syndicates and real estate investment trusts, REITs, offer different avenues for collective investment, each with distinct operational and tax implications.
Syndicates first, what are those?
Syndicates typically consist of one sponsor who actively manages the project and a group of passive investors who provide capital. They are commonly used for large commercial real estate projects and go through a clear three-phase cycle. First, organization, which includes planning, acquiring property, and satisfying legal registration and disclosure rules. Second, operation, where the sponsor manages both the syndicate itself and the underlying real property. And finally, liquidation, which is the resale of the property, effectively completing the venture.
So it's kind of a one-shot deal for a specific project.
Often, yes. This structure is often a one-off endeavor, contrasting with a joint venture, which is more about ongoing collaboration.
And REITs are something you hear about on the stock market, right? Like a way for everyday people to invest in large real estate portfolios without actually buying property themselves.
Precisely. Real estate investment trusts, REITs, are a special type of syndicate, but they are organized as a trust and own income-producing real estate or real estate assets. Investors buy shares in the trust, making it highly liquid, similar to investing in stocks.
Ah, so easy to buy and sell.
Relatively, yes. The trust then uses that pooled money to purchase and manage a diverse portfolio of properties. To qualify as a REIT for favorable tax purposes, they must meet specific criteria, including requirements regarding their shareholders, the percentage of their income derived from real estate, and the types of assets they hold.
Okay.
Most REITs are equity REITs, which directly own and operate properties, generating income from rents. But there are also mortgage REITs that invest in real estate loans and hybrid REITs that combine both approaches. The core insight here is that REITs are a fantastic liquid way for smaller investors to participate in large-scale real estate without the direct management burden, offering diversification in income.
Uh,
3. Encumbrances and liens, understanding claims on property.
Moving on to restrictions that can affect your property, it's not just governments telling you what you can do with your land through zoning laws. Private entities also play a powerful and often surprising role in dictating property use.
What's truly fascinating here is this dual layer of control, almost like a parallel set of rules to public zoning. Private land use controls, most commonly known as deed restrictions or covenants, conditions and restrictions, CCRs, are put in place by non-governmental entities like real estate developers.
Repeat HOA rules again?
Often, yes. Put in place often to maintain a certain aesthetic or standard within a subdivision. Think of a neighborhood that mandates specific roofing materials or house colors. That's likely a CCR at work. These restrictions are generally considered valid if they are reasonable restraints and genuinely benefit all property owners in that subdivision.
But they can't break anything, right?
No, absolutely not. A crucial point is they may not violate local, state, or federal laws. For instance, any deed restriction that attempts to violate fair housing laws, such as restricting who can buy based on religion or race, is absolutely not enforceable.
Okay, good. So if there's a conflict between a private restriction and, say, a city zoning law, which one wins for the property owner?
That's where the strictest rule comes into play. If a zoning ordinance and a deed restriction conflict, the more restrictive rule is the one landowners must follow.
Ah, so whichever one limits you more.
Generally, yes. So if a zoning law says you can build a 3-story house, but a deed restriction says only 2 stories, you're limited to 2 stories. However, if a deed restriction itself conflicts with an overarching law, it's simply unenforceable. Another important concept is the doctrine of laches.
Latches sounds old.
It is an old legal principle. It essentially prevents enforcement of a deed restriction if it hasn't been enforced when violations initially occurred. It's a safeguard to ensure fair and consistent application.
Meaning you can't suddenly decide to enforce a rule you've ignored for years.
Exactly. You can't selectively enforce rules against certain neighbors if you've ignored the same violation by others for years. The core insight is that private restrictions can be incredibly powerful, sometimes even more so than public zoning, but they must always align with fundamental laws and be enforced consistently.
So what exactly is an encumbrance? It sounds a bit ominous, like something negative, but it's a critical concept in real estate that every property owner should understand because it affects the property's very title.
An encumbrance isn't necessarily bad, but it is a significant factor to be aware of. Think of it as a cloud or a shadow on your property's title. It's a non-possessory interest in a property that burdens its title, affecting its transferability or use without preventing the transfer of ownership itself.
So it doesn't stop a sale, but it makes it messier.
It can, or it just limits what you can do. It's a claim or right held by someone else against your property. The main categories of encumbrances include liens, which are financial claims like a mortgage or unpaid taxes, allowing someone to seize the property if the debt isn't paid. Easements, the right to use another's land for a specific purpose, which we'll delve into shortly. Deed restrictions, those private land use controls we just discussed. And a cloud on the title, which signifies a dispute or unresolved issue that prevents an otherwise clear title.
So these are things that burden the title. What about other situations that affect property but aren't strictly encumbrances in the same legal sense?
That's a good distinction. While not considered encumbrances in the same legal sense, other concepts can also affect property. A license is a revocable and temporary permission to use someone else's property for a specific purpose, like permission to park in a neighbor's driveway for a day, or walking through your neighbor's yard to retrieve a ball.
So it's not a permanent right.
Yeah, exactly. It's a personal privilege, not an actual interest in the land, and can be withdrawn at any time. Then there are encroachments, which are physical structures or property that crosses a boundary into a neighbor's land, such as a fence built slightly over the property line, or a tree branch hanging too far into your yard.
Uh-oh. Neighbor disputes waiting to happen.
Often, yes. The key takeaway here is the difference between a license and an easement. A license is temporary and revocable, whereas an easement is a more permanent and typically irrevocable right tied to the land itself or a specific person.
That makes the distinction much clearer. And speaking of easements, they are incredibly common and vital to understand. They grant a specific right over someone else's land without granting ownership. How can properties have shared access or limitations without changing who actually owns the land?
Precisely. Easements are everywhere. and they come in different forms based on their purpose. An affirmative easement gives someone the right to use a property for a specific purpose. Most easements fall into this category.
Like the utility company needing access.
Exactly. Or a right-of-way that allows a neighbor to cross your property to access their own, otherwise landlocked parcel. Conversely, a negative easement prevents a property owner from doing something on their own land that would otherwise be legal.
Like blocking a view.
That's the classic example. An easement that prevents you from building above a certain height, ensuring your neighbor's scenic view isn't blocked. It's a right to prevent something.
And how are these easements usually set up or attached to a property? Are they always tied to the land?
There are two main ways they're attached. An easement appurtenant runs with the land, meaning it benefits an adjacent property and transfers automatically with property ownership.
So if I buy the house that benefits, I get the easement too.
Correct. So if property A has an easement appurtenant to cross property B to reach the road, then anyone who buys property A automatically gets that right. It's about the land benefiting. Then there's an easement in gross, which is tied to a specific person or entity, not the land itself.
Like the utility company again?
Yes, or a billboard company's right to maintain a sign on your property would be examples of easements in gross. These don't necessarily benefit an adjacent parcel. They benefit the holder of the easement, personally or corporately.
So once an easement is created, whether it's for a view or a utility line, how can it be removed or ended? Are they permanent?
No, they're not necessarily permanent. Easements can be terminated through various means, including abandonment, when the easement holder clearly shows intent to give it up and stops using it; release, the holder formally gives up the right in writing; prescription, if the purpose for which the easement was granted ceases to exist or if someone else uses it adversely for a long period; merger, if the dominant and servient properties, the ones that benefit and are burdened, come under one ownership.
If you buy the neighbor's house too.
Right. Also, expiration of purpose, if the reason for the easement no longer exists, for example, if the road it provided access to is no longer there, or through court action if there's a dispute. The core insight for easements is that they create rights of use, not ownership, and their type determines their transferability and permanence.
You mentioned adverse possession earlier when talking about involuntary transfers of property. How does that relate to or differ from a prescriptive easement? They sound quite similar, both about using someone else's land over time.
You're right, they do sound similar, and they share many elements, but the distinction is absolutely crucial. Both adverse possession and a prescriptive easement involve long-term, non-permissive use of another's property.
Without permission. Key point.
Absolutely. To establish either in California, the use must be hostile, meaning against the owner's wishes without permission, actual physically occupying or using the land, not just claiming it, open and notorious, visible to the owner, not hidden, continuous for a period of 5 years, and under a claim of right. The person believes they have a right to use or possess it, even if that belief is mistaken.
Okay, so that's a lot of similarities. What's the defining difference, especially here in California?
Here's the key distinction, and it's massive. A prescriptive easement grants only the right to use the property for a specific purpose, like crossing a pathway or maintaining a fence. Successful adverse possession, on the other hand, grants ownership of the property itself.
Wow, full ownership.
Yes, a full title transfer. But the barrier to adverse possession is significantly higher in California. It uniquely requires the adverse possessor to have paid all real property taxes on that specific property for those 5 consecutive years.
Ah, they have to pay the taxes too.
Correct. This additional tax payment requirement makes successful claims of adverse possession far less common and much more difficult to prove than claims for prescriptive easements. The core insight is that while both involve long-term use, one grants use, the other grants ownership, and the tax requirement is California's unique hurdle.
From rights of use, we move to liens financial claims against property. These are oft out ensuring debts are paid, and they are foundational to how property secures loans and obligations, which is obviously critical for buyers and sellers.
Absolutely. A lien is essentially a financial claim or charge against property, typically serving as security for a debt. It gives the lien holder the right to have the property sold to satisfy that debt if the owner defaults.
So the property itself backs up the debt.
Exactly. Liens can be categorized in a couple of important ways. A voluntary lien is created on purpose with the property owner's consent. The most common example is a mortgage taken out to purchase a home. You willingly offer your property as collateral for that loan.
So a mortgage is a voluntary lien. What's the opposite? Something imposed on you.
The opposite is an involuntary lien, which is imposed by law without the owner's explicit agreement. These often arise due to unpaid debts or legal judgments. Examples include a mechanic's lien, which could be placed on a property by a contractor or supplier for unpaid work or materials on that specific property.
Like if you didn't pay the roofer.
Right. Or a tax lien, which secures unpaid property taxes. Liens are also classified by their scope. A general lien is a broad claim for which both the real estate and personal property of the debtor may be sold to satisfy the debt. Think of a judgment lien arising from a lawsuit, which could attach to all of a person's assets, not just one piece of property.
Okay, that's broad.
It is. In contrast, a specific lien applies to a certain property only. Personal property is not affected. Mortgage liens, property tax liens, and mechanics liens are all examples of specific liens as they are attached to a particular piece of real estate.
This raises an incredibly important question about who gets paid first if a property is sold under duress, like in a foreclosure. How do these liens stack up in terms of priority? If I have a mortgage, and then property taxes, and then a judgment against me, who gets their money first?
This is critical, and it's where many people misunderstand the game. Liens are commonly prioritized by the first in time is first in line rule. This means that liens recorded earliest in the public records typically have senior priority. So an older mortgage generally gets paid before a newer one.
First come, first served. Makes sense.
But there's a critical exception to this fundamental rule that you absolutely need to remember. Ad valorem, property taxes, and special assessments for specific improvements benefiting the property always take priority over any other kinds of liens, regardless of the recording date.
Always, even before the first mortgage.
Always. They're automatically in first position, meaning they get paid first, even before an older, previously recorded mortgage. The core insight here is that your local government always comes first, no matter what. A senior lien is one that comes first in priority, while a junior lien is superseded by another lien. It's possible for parties to agree to change the typical priority order through a subordination agreement, where a later recorded mortgage is given priority over a previously recorded one, for example. If a homeowner wants to refinance their first mortgage, the second mortgage holder might agree to stay in second position, even though the first mortgage is technically new.
Ah, okay. They can agree to switch places.
Right. Finally, it's worth knowing about a lis pendens, which is a document recorded at the courthouse giving public notice that a lawsuit is pending on a particular piece of property. While not a lien itself, think of it like a big official sticky note on the property's file, warning everyone, hey, there's a lawsuit cooking here.
So it clouds the title, potentially.
It certainly can affect the property's marketability and future lien status. 4. Agency principles, the bedrock of real estate relationships.
Moving into the realm of relationships, we need to understand agency, the core of how real estate professionals interact with their clients. For you, the buyer or seller, this is all about who is looking out for your best interests and what their legal obligations actually are.
This is foundational because agency is fundamentally about one party, the agent, acting on behalf of another, the principal, with a fiduciary obligation.
Fiduciary. Big word. What does it mean?
It means the agent must always act in the client's best interest, highest duty of trust and loyalty. This relationship is typically created at the broker level through mutual consent, meaning both the client and the broker agree to enter into this arrangement. It's incredibly important to distinguish between a client and a customer. An agent works for a client who is their principal and owes them comprehensive fiduciary duties. They work with a customer to whom they owe fairness and honesty, but not that higher level of fiduciary duties or the same deep loyalty.
Okay, so there's a big difference in obligation there.
Huge difference.
So what exactly are those fiduciary duties? I hear that term thrown around a lot, but what does it practically mean for the agent's responsibilities to their client, and how does it protect me?
These are the highest levels of trust and confidence owed to a client, ensuring their best interests are always paramount. They can be easily remembered by the acronym OLD-CAR.
OLD-CAR.
Okay. Obedience. The agent must follow all legal and ethical instructions from the client. If you tell your agent to offer X amount, they must do it, assuming it's legal. Loyalty. The agent must represent the client's best interests, even above their own personal gain. This means putting your goals first.
Their interests second.
Exactly. Disclosure. The agent must reveal all material facts relevant to the transaction to their client. If it affects the client's decision, positive or negative, it must be disclosed. This is why agents ask so many questions.
Gotcha. Confidentiality.
Right. The agent must keep the client's private information private. This duty is incredibly important and lasts forever, even after the agency agreement ends.
Forever. Wow.
Yep. This means past pricing strategies, personal motivations for selling, or specific financial details are strictly confidential. Accounting. Proper handling of all funds and meticulous record-keeping related to the transaction. This is also a forever duty. An agent must always be able to account for any money or documents they've handled on your behalf.
Okay. And are.
Reasonable skill and care. The agent must employ their professional expertise on the client's behalf, exercising the care and diligence expected of a licensed professional. They can't be negligent or sloppy.
Makes sense.
The core insight here is that these duties create a powerful legal bond, ensuring your agent acts almost as an extension of you, always prioritizing your interests. Even without a fiduciary relationship, agents still owe honesty, fair dealing, and disclosure of material facts to customers or third parties. They can't lie to anyone.
The level of authority an agent has varies greatly. It's not a one-size-fits-all authorization from a very narrow single task to incredibly broad decision-making power. What are these different classifications and how do they define an agent's mandate?
That's a great way to put it, because these classifications define the agent's mandate and the scope of their power. Most real estate relationships fall into specific categories, which dictate the agent's responsibilities and limitations.
Okay.
Special agency is the most common example in real estate. This relationship, like that between a real estate broker and their client, is narrowly defined for a single short-term objective. For example, selling a specific property or finding a specific property to buy.
So just handle this one deal.
Right. The agent does not have binding authority on behalf of the principal. They cannot sign contracts or make major decisions for the client without explicit case-by-case permission. General agency is broader than special agency, authorizing a range of activities within a specific area of concern for the principal, and it's often ongoing. A common example is the relationship between a broker and their associate licensee, a salesperson or broker associate.
Like the agent working for the broker.
Exactly. The associate licensee typically has binding authority within the scope of their assigned duties for the brokerage. They can list properties, show homes, and negotiate on behalf of the brokerage. Universal agency represents the broadest scope. It gives agents the power to act and make decisions on behalf of the principal in all business matters across a wide range of concerns.
Like a power of attorney.
Precisely. This is rarely used in real estate transactions, typically requiring a power of attorney document to grant such extensive authority, making the agent an attorney in fact. The core insight here is that while all agents act on your behalf, their legal authority can range from highly specific to almost limitless. So understanding their classification is key to understanding their power.
California specifically allows for different agency types to navigate transactions, and understanding them is crucial for all parties involved as it defines who is representing whom and with what level of loyalty. This has huge implications for buyers and sellers.
It absolutely does, and this raises an important question about how representation is structured in California and the potential conflicts that can arise. The key in all these structures is transparency and informed consent.
So everyone knows who works for whom.
Ideally, yes.
Yeah.
Single agent, exclusive agency. This is where one agent or brokerage represents one party in a real estate transaction. This party can be a buyer, a seller, a landlord, or a tenant. The agent owes undivided loyalty and all full fiduciary duties solely to that one client.
Clean and simple.
Right. A seller agent works tirelessly to find a ready, willing, and able buyer for the seller's property, typically through a written listing agreement. A buyer agent works just as diligently to find a suitable property for the buyer, at terms acceptable to the buyer, usually through a buyer-broker agreement. It's a clear, straightforward relationship.
So what happens if the same brokerage ends up representing both the buyer and seller in the same deal? That feels like a huge conflict of interest, doesn't it? How can one brokerage truly represent two parties whose goals might be fundamentally opposed, like a buyer wanting a lower price and a seller wanting a higher one?
You've hit on the precise tension. This is where dual agency comes in. It occurs when the same brokerage represents both the buyer and the seller in a single transaction.
How can that even happen?
Well, it can happen if one agent within the brokerage represents the seller and another agent from the same brokerage represents the buyer on the same property, or even if a single agent works directly with both parties. The critical point here is that dual agency necessitates limited loyalty and a compromise on full disclosure, because the parties have inherently conflicting interests, particularly regarding price and terms.
So they can't give full advice to either side.
Exactly. An agent cannot advise both parties on the best negotiation strategy, for instance. Because of this compromise service, California law legally requires both parties to give informed consent in writing to dual agency.
Written consent is key.
Absolutely. California Association of Realtors forms like Form AD, disclosure regarding real estate agency relationship, and Form AC, confirmation of real estate agency relationships, are commonly used for this disclosure and confirmation process. It's a very serious matter. Agents who knowingly practice undisclosed dual agency can face severe consequences, including losing their license, losing their commission from the transaction, and even facing legal action.
Wow. Serious stuff.
It is. The core insight here is that dual agency is permitted, but it comes with limitations on the agent's loyalty and requires explicit written consent to protect all parties.
And what about a subagent? That term can be a bit confusing, especially given the complexities of different agents and brokerages.
A subagent is essentially an agent of an agent. This typically arises when an agent enlists other agents to accomplish a client's goal. For example, an unaffiliated cooperating broker from another brokerage might help a listing broker find a buyer for the listing broker's seller client without representing the buyer as a buyer's agent.
So they're helping the seller's agent, not the buyer.
In that scenario, yes. In this scenario, the subagent owes the principal of the original agent, the seller in this case, the same fiduciary duties as the original agent. However, in California, cooperative brokers operating as subagents are rare,
Why is that?
largely due to the significant vicarious liability the listing broker assumes for their actions, even without direct sponsorship or employment. Brokers often opt not to offer subagency opportunities through the multiple listing service, MLS, for this very reason, preferring to work with buyer's agents who represent their own client. It's just less risky for the listing broker.
How do these critical relationships begin, and how do they end? It's not always as simple as a handshake, especially with the strict legal requirements in real estate.
That's a great question, because if we connect this to the bigger picture, the legal framework for creating and terminating agency is designed to protect all parties and ensure clarity, even if the real-world implications can be complex. Creation of agency fundamentally relies on mutual agreement. In California real estate, agency agreements must be in writing to be enforceable, such as a listing agreement for a seller or a buyer representation agreement for a buyer.
Get it in writing.
Always. This isn't just a suggestion, it's a legal requirement for your protection. There are various ways agency can be created beyond that explicit written contract, though. Express agency is created by explicit appointment, either oral or, as required in CA real estate, written. Implied agency is created through actions, conduct, and words, even without an explicit written agreement.
So you can accidentally create agency.
Yeah, you absolutely can. This is why agents must be incredibly careful with their words and actions, as implied agency can create unintended fiduciary duties that they might not have intended to take on. Then there's agency by ratification, which is an after-the-fact approval by a principal of an agent's unauthorized actions, like if your agent did something outside their scope, but you approved it later.
Okay.
Ostensible agency, or agency by estoppel, is created when a principal's actions or inactions cause a third party to reasonably believe an agent has authority, and the principal is then legally prevented from denying it. Think of it as, if you let your agent act like they have certain authority, you might be bound by their actions even if you didn't give them formal permission.
Be careful what you let your agent do.
Right. Finally, there's gratuitous agency, created without an expectation of compensation for the agent, though it's important to remember that compensation does not equal agency. Just because you pay someone doesn't automatically make them your agent with full fiduciary duties. The core insight is that agency is a powerful legal relationship, and it can be formed in ways you might not even realize, underscoring the need for clear written agreements.
And how do these relationships typically come to an end?
Agency relationships can be terminated through two primary umbrellas: operation of law, meaning automatic termination due to circumstances beyond the party's control, or acts of the parties, meaning actions taken by one or both parties.
Operation of law first. What triggers that?
Operation of law causes include performance, when the purpose of the agency is fulfilled, like a property being sold and the transaction closing; expiration of the agreement term; destruction or condemnation of the subject property. If the house burns down, the agency agreement ends.
Makes sense.
Death, incapacitation, or bankruptcy of either the principal or the broker, or the loss of the broker's license. These are all events that legally dissolve the relationship without anyone needing to actively do anything.
And what about acts of the parties?
Acts of the parties' causes include Mutual agreement to terminate early, revocation when the principal unilaterally terminates the agreement, renunciation when the agent unilaterally terminates, or breach of agreement by either party. It's important to note that while a party has the right to unilaterally revoke or renounce, it doesn't necessarily mean they won't incur liability for breaching the contract. There might be penalties.
So you can fire your agent, but you might still owe them something.
Potentially, depending on the agreement. Also, there's a special situation called agency coupled with an interest. If the broker has a financial or ownership interest in the property beyond just commission, for instance, if they've invested money in the property themselves, the client does not have the right to unilaterally revoke the agency agreement. This protects the broker's direct investment.
That's a crucial point. Does anything from the agency relationship survive even after it's officially terminated?
Absolutely. Even after termination, the fiduciary duties of confidentiality and accounting survive and continue indefinitely.
The forever duties.
Exactly. This means the agent can never reveal confidential client information, nor can they cease to properly account for any funds or records related to the past transaction. The core insight here is that while the active relationship ends, the agent's professional and ethical obligations regarding your private information and funds last forever. Acquisition and transfer of title, from deed to closing.
So when you buy a house, what are you actually getting? Are you getting a title or a deed? Many people use these terms interchangeably, but our sources clearly show they're distinctly different, and understanding that difference is fundamental.
That's such an important clarification. What's fascinating here is that title isn't a physical document you hold in your hand. Title is the actual legal ownership of a real property. It's the concept of having all those rights we talked about earlier, the bundle of rights, like the right to possess, control, enjoy, exclude, and dispose of the property.
It's the idea of ownership.
Exactly. It's a conceptual legal right that proves you have legitimate ownership. A deed, on the other hand, is the physical legal document that formally transfers that real estate title from one party to another. Its primary purpose is to create official public records showing property ownership changes, and to serve as tangible evidence that the person holding the deed has the underlying legal title.
So you hold the deed as evidence of your title, but the title itself is the underlying legal right to the property.
You got it, the core insight. You hold the deed to prove you have title.
Property transfer isn't just about selling. Our sources break down the ways property can change hands into two main categories, highlighting that ownership shifts can happen voluntarily or sometimes involuntarily without the owner's choice.
If we connect this to the bigger picture, understanding these different forms of alienation, which simply means the act of transferring property, highlights the various legal mechanisms by which property rights shift, whether by choice or by legal decree. Voluntary alienation is transfer by choice or agreement.
Like selling my house.
Right. Examples include a private grant, which is most common, involving selling or gifting property to an individual; dedication, where property is gifted by the owner to the government for public use, such as for a park or street; a public grant, which is the government giving land to a private entity, for example, for development; or devise, which is transferring property through a will upon death.
So voluntary is about the owner's intent, their decision to transfer. What about involuntary transfers where the owner doesn't really have a say?
Involuntary alienation is transfer without the owner's consent, usually by operation of law, and these can be unsettling for an owner. Examples include eminent domain.
The government taking land.
Right, where the government takes private land for public use, providing just compensation, such as for building a highway; foreclosure, where a lender seizes the property after the owner defaults on a loan, for example, not making mortgage payments; lawsuits, such as a quiet title suit, brought to remove any outstanding claims or defects on the title, forcing a clarification of ownership; adverse possession, which we discussed, where an involuntary title transfer occurs to another person who claims the land and possesses it hostilely and openly for a statutory period, paying taxes in California, escheat.
That's when the state gets it if there are no heirs.
Correct, where the state takes property when an owner dies without a will and no legal heirs; and forfeiture of title, which happens when a specific condition in a deed is violated, causing ownership to revert to a previous owner. The core insight here is that while we typically think of buying and selling, property can actually change hands in many ways, some of which are entirely out of the owner's control.
Not just any piece of paper counts as a deed. There are specific legal requirements for a deed to be considered valid, especially here in California, to ensure the transfer is legally sound and enforceable.
This raises an important question about legal enforceability and protecting your ownership. In California, for a deed to be considered valid, it must be signed and acknowledged by the grantor, the person conveying the property.
Signed and notarized.
Exactly. Acknowledged means it's been notarized, confirming the grantor's identity. Interestingly, grantees, the people receiving the property, only need to sign if they're taking title with rights of survivorship, and if so, they must sign in front of a notary.
Okay.
While California doesn't actually require a deed to be recorded in public records to be valid between the buyer and seller, an unrecorded deed can be invalidated by a later recorded deed if a third party buys the property without knowledge of the first transfer.
So recording is super important for protection.
Absolutely crucial. For practical protection, recording the deed in public records is absolutely crucial. It provides constructive notice to the world, meaning everyone is legally presumed to know about the ownership change, thereby protecting buyers and lien holders. The core insight is that while a signed deed transfers ownership, recording it is your ultimate safeguard.
Deeds come in different flavors, each offering varying levels of protection to the new owner, the grantee. It's not a uniform guarantee of a property's history, which is critical to understand when you're receiving one.
What's truly fascinating here is the implicit promise made by the grantor, the person conveying the property, depending on the type of deed used. The type of deed signals the extent of the grantor's guarantee regarding the property's title history, and thus the risk to the new owner.
What's the best kind, then?
The warranty deed is the strongest type, offering the broadest guarantee of title. The grantor essentially vouches for the title throughout his entire history, promising to defend the grantee against any claims, even those from before their own ownership.
Covers everything.
Pretty much. This deed includes 6 covenants or promises, such as the covenant of season. The grantor holds title and has the right to convey it, and the covenant of warranty forever. The grantor will compensate the grantee for losses if the title fails at any point in the future due to a title defect.
And what's common in California?
The grant deed, which is very common in California, offers a more limited guarantee. This deed only protects against defects that occurred while the grantor held title to the property.
So only during their ownership period.
Right. It implies that the grantor hasn't already conveyed the property to someone else, and that the property is free of undisclosed encumbrances created by the grantor. It doesn't guarantee the title's history before their ownership.
Okay. And the weakest?
The quitclaim deed is the weakest form. This type conveys any interest, title, or right the grantor may have at the time the deed is executed, without guaranteeing any actual ownership or defending against any claims.
So it's like saying, whatever I might own, if anything, is yours now.
Exactly. It's often used to clear a cloud on the title or resolve a dispute among family members. Imagine someone saying, I might have an interest in this property, and if I do, I'm giving it up. It offers minimal protection to the grantee and is rarely used for standard sales. It's important to note that bargain and sale deeds are not used in California for property transfers.
Good to know.
The core insight here is that the deed you receive dictates the level of assurance you have about your new property's history, so always know what kind of deed you're getting.
Property also changes hands when someone passes away, and this process has its own legal distinctions depending on whether a valid will exists. This is a common life event with significant real estate implications.
If we connect this to the bigger picture, estate planning plays a crucial role here, influencing how smoothly and efficiently property is transferred after death. The process of transferring property differs significantly based on whether a person dies testate, meaning they left a valid will, or intestate, meaning they died without one.
Testate with a will, intestate without.
Correct. If there's a will, an executor is named within it to carry out its provisions, including the disbursement of property according to the deceased's wishes. If no will exists, a court appoints an administrator, also known as a personal representative, to oversee the administration and distribution of the estate according to state law.
So the court steps in if there's no will.
Right. Both the executor and the administrator are responsible for paying federal estate taxes, state inheritance taxes, and any other claims against the estate before property can be distributed to heirs. The core insight is that having a valid will ensures your property goes where you intend, minimizing legal complexities for your loved ones.
So ensuring you have a good or marketable title is paramount when buying property. What exactly makes a title marketable, and why is it so important to get title insurance? It sounds like the final piece of the puzzle to truly secure your ownership.
This raises an important question about risk mitigation in real estate. A marketable title is crucial because it's a title that is free from serious defects, free from legal exposure, and is reasonably expected to be sellable in the future. Essentially, it's a title that a reasonable buyer would accept without fear of litigation or hidden encumbrances that would diminish its value.
It's a clean title,
You
basically.
could say that. The sources emphasize that title insurance is a key method of providing evidence of a marketable title. California, for example, does not use the Torrens system for title registration, which is a government-run title recording system, making title insurance even more vital as the primary protection.
So what does title insurance actually do?
Title insurance is a policy that protects homeowners and lenders from financial losses due to title issues that may have existed before the purchase, such as undisclosed defects, encumbrances, or liens, even if they weren't found in the initial title search.
Covers things missed in the search.
Exactly. Things like forgery, undisclosed errors, errors in public records, things that might pop up later. There are two main types: an owner's title insurance policy, which protects a buyer, and is optional, though highly recommended because it protects your equity, and the lender's title insurance policy, mortgagee's title policy, which protects the lender and is mandatory for most loans because the lender needs to ensure their collateral is clear.
Lender always gets protected.
Pretty much. In California, the customary practice is for the buyer to pay for the lender's policy and the seller to pay for the owner's policy, though this is always negotiable between the parties.
Who pays is negotiable. Interesting.
Very much so. After a title search, the title company issues a title commitment, which is a document stating the terms and conditions on which the actual policy will be issued. It's essentially a promise to insure, and it includes the property's legal description, any exceptions, found encumbrances or defects that won't be covered, and conditions that need to be met before closing.
Like a preview of the policy.
Right. Finally, it's worth noting the real estate documentary transfer tax, a state tax on the sale of real property in California, currently $1.55 per $500 of value, with counties and cities potentially adding their own local taxes on top of this. This tax is usually paid by the seller, but is also negotiable.
Another cost to be aware of.
And, of course, homeowners insurance is required by lenders to cover the loan amount against physical property damage, theft, and liability. The core insight here is that title insurance is your financial shield against the unexpected ghosts of a property's past, ensuring your ownership is secure. 6. The lending process, securing your real estate investment.
For most people, buying a property means getting a loan, often the largest financial commitment of their lives. So let's break down the lending process. From the very first step of gauging your eligibility to getting that crucial final approval. It's a journey with a lot of hoops to jump through.
You're right. It's a multi-step, rigorous process lenders undertake to assess risk. It begins with a general idea and progresses to deep financial scrutiny, ultimately determining your creditworthiness. The first informal step is pre-qualification.
Pre-qual. I hear that a lot.
Right. It's an initial informal estimate of loan amount based solely on your stated financial information. The lender essentially takes your word for it. It's a quick chat to see if you're in the ballpark. Think of it as a casual conversation.
And then there's pre-approval, which sounds much more serious and I imagine much more powerful for a buyer.
It absolutely is. Pre-approval is a more formal and much more powerful step. Here, a lender actually reviews your qualifications by examining documents like your pay stubs, bank statements, and pulling your credit report.
They actually check your info.
Yes. If approved, the lender provides a pre-approval letter indicating their confirmed ability to obtain financing up to a certain amount. This is a powerful tool for buyers when making offers, as it signals to sellers that you are serious and financially capable, giving you a strong advantage. The final, in-depth analysis is underwriting.
The final boss?
Sort of. It occurs after a purchase offer contract has been entered. An underwriter makes a final assessment of your creditworthiness and thoroughly evaluates the property itself as collateral for the loan. Underwriters typically examine 5 key aspects of a borrower's financial profile: their income, can they afford the payments? Credit history and score, like the FICO score, where a minimum of 580 is typically required for FHA loans, indicating your repayment reliability. Their available assets, do you have enough cash for the down payment and closing costs? Their existing debts, how much other debt are you carrying?
Right.
And their overall net worth, calculated as assets minus debts, providing a full financial picture.
They look at everything.
They really do. The core insight here is that pre-qualification is a guess, pre-approval is a commitment, and underwriting is the final deep dive into your ability to pay.
Lenders aren't just looking at your income, they're crunching specific numbers, these qualifying ratios, to ensure you can truly afford the monthly payments. It's all about ensuring you're not getting in over your head.
That's spot on. These qualifying ratios are key gates for loan eligibility and are designed to prevent borrowers from taking on more debt than they can comfortably manage. The first is the payment-to-income ratio, often called the front-end ratio or housing expense ratio.
Okay, front end, what's that measure?
This compares your estimated monthly housing payment, which includes principal, interest, property taxes, and homeowners insurance, often remembered as PITI, to your gross monthly income. For example, for conventional loans, your PITI usually can't exceed 28% of your gross monthly income, while for FHA loans, it's typically a bit more lenient at 31%.
And then there's the broader one that looks at all your other debts too, right? Because a mortgage isn't your only bill.
Exactly. That's the debt-to-income ratio, or back-end ratio, or total debt service-to-income ratio.
Back end ratio, got it.
This is a broader measure that divides all your monthly debt payments, including your housing payment, plus other debts like credit card minimums, car loans, student loans, and other installment payments by your gross monthly income. For manually underwritten conventional loans, this total debt often can't exceed 36% of your gross monthly income, and for FHA loans, it's typically 43%.
So it includes everything else you owe.
Right. These ratios give lenders a comprehensive view of your total financial obligations versus your income, allowing them to assess your ability to make payments consistently. The core insight is that these ratios are the lender's safety net for your finances, ensuring you don't end up in over your head.
It's not just about you, the borrower. The property itself needs to pass muster with the lender. After all, it's the collateral for the loan, so its value and condition are critical.
Absolutely. If we connect this to the bigger picture, the lender's primary concern is ensuring their loan is adequately secured. The property's value is critical collateral in case of borrower default. To approve the property, the underwriter conducts various due diligence activities. This includes a title search to verify ownership and identify any existing claims or liens, an appraisal performed by a licensed appraiser to estimate the property's current market value.
Making sure the house is worth what you're paying.
And what they're lending.
Yeah.
And red flag investigations for anything unusual, like recent unpermitted property improvements or potential environmental issues.
So the appraisal really determines how much the lender is willing to lend. That's where the loan-to-value ratio comes in, correct?
Precisely. The loan-to-value ratio, LTV, is a key metric here. This is the ratio of the loan amount to the property's appraised value. The higher the LTV, the riskier the loan for the lender, because they have less of an equity cushion if property values decline or the borrower defaults.
Less skin in the game for the borrower, basically.
That's one way to look at it. For example, conventional loans typically have an LTV of 80% or less, meaning you need a 20% or more down payment. If you have an LTV greater than 80%, it usually requires private mortgage insurance, PMI, to protect the lender from default.
That extra insurance cost.
Right. Conventional loans generally max out at 95% LTV with PMI. In contrast, VA loans, backed by the Department of Veterans Affairs, can allow for 100% LTV, meaning no down payment for eligible veterans. FHA loans, insured by the Federal Housing Administration, allow for an LTV up to 96.5%, requiring only a 3.5% down payment.
Different programs have different LTV rules.
Yes. For commercial properties, especially income-producing ones, lenders use a specific metric called the debt service coverage ratio, DSCR, which is the net operating income divided by the total debt service. This ratio ensures the property itself can generate enough cash flow to comfortably cover its debt obligations.
Make sure the rent covers the mortgage and then some.
Essentially, yes. The core insight is that the LTV is the lender's measure of risk, directly influencing your down payment and whether you'll need mortgage insurance.
After all the approvals, both for you as a borrower and for the property itself, we get to the final, exciting steps of securing the loan and officially becoming homeowners. This is where all the paperwork finally comes together, often a flurry of signatures.
That's right. And what's fascinating here is the role of standardized forms and consumer protection laws in making the lending process transparent and understandable for you, the borrower. Government influence is significant, with laws like the Truth in Lending Act, TILA, ensuring clear credit term disclosures, and RESPEC, Real Estate Settlement Procedures Act, regulating the entire lending process to prevent kickbacks and ensure transparency of costs.
Rules to protect the consumer.
Exactly. The Consumer Financial Protection Bureau, CFPB, plays a central role in enforcing these federal consumer financial laws. Two critical documents you'll encounter are the loan estimate, LE, and the closing disclosure, CD.
LE and CD. Okay.
The loan estimate is a crucial form that combines and replaces older disclosures. It highlights the most important elements of the transaction, allowing for easy comparisons among competing lenders. The lender is legally obligated to deliver or mail the loan estimate form by the third business day after receiving your loan application.
So you get it early to compare offers.
That's the idea. Then, the closing disclosure combines and replaces the old HUD-1 settlement statement. It provides the final details about the mortgage loan, including all the costs. The borrower must receive the closing disclosure at least 3 business days before the scheduled closing day.
3 days before closing. Why?
To give you time. Missing this deadline will typically delay the closing to ensure you have ample time to review everything and ask questions before signing. No surprises at the closing table.
And what about points and other costs that come up at closing? That's always a surprise for first-time buyers.
It can be. Discount points are prepaid interest points paid by the borrower at closing to reduce the interest rate over the life of the loan. 1 point equals 1% of the loan principal.
Pay more now to save later on interest.
Exactly. So on a $300,000 loan, 1 point costs $3,000 up front, but could save you money over decades. Lender credits are the reverse. You pay a slightly higher interest rate, and the lender gives you money to offset some of your closing costs.
Like getting cash back at closing, but with a higher rate.
Right. The total amount a buyer needs to bring to closing is called cash to close. This figure includes all fees, taxes, prepaid items, escrow funds, title policy costs, points, and the down payment. This vital number is clearly outlined on both the loan estimate and the closing disclosure forms.
The bottom line number.
Pretty much. Once the loan commitment, the lender's official approval of a specific loan for a specific property is issued, the final steps involve the lender depositing the loan amount with the escrow agent and the borrower depositing the down payment and other closing costs. You sign all final documents, the title is then transferred and recorded, providing constructive notice to the world, and finally the funds are dispersed to the seller and you officially take possession of your new home.
Keys in hand.
That's the moment. The core insight. These standardized forms and timelines are your legal safeguards, empowering you to understand and compare costs before you commit. 7. Leasehold interests. The world of renting and leasing.
We've talked a lot about outright ownership, but what about renting? That's where leasehold interests come in, creating a different kind of relationship with property, one that doesn't involve outright ownership, but still gives you rights.
Exactly. This raises an important question about the fundamental difference between owning property, which is a freehold estate, meaning you own it freely, and merely having the right to occupy it, which is a leasehold interest.
Freehold versus leasehold.
Okay. A leasehold does not include ownership. It's simply an interest in the occupation of a property established through a lease contract. A lease is a legally binding agreement where one party, the lessor or landlord, conveys the right to use their property to another, the lessee or tenant, for a specific predetermined period, usually in return for periodic rent payments.
Landlord and tenant agreement.
Right. In California, leases for 1 year or longer must be in writing to be legally valid and enforceable, though it's always recommended for all leases to be in writing for clarity and protection for both parties.
Even short ones, probably a good idea.
Always a good idea. The core insight. A leasehold gives you the right to use a property, not to own it, and that right is defined by a contract.
Not all leases are the same. They come in different forms depending on the agreement structure and duration, which defines the nature of the tenant's occupancy. It's not just a simple month-to-month.
You're right, and what's fascinating here is how these distinctions classify the nature of the occupancy, from fixed terms to indefinite arrangements, each with specific rights and responsibilities.
What are the main types?
An estate for years, also known as a tenancy for years, is a lease with a specific starting and ending date. The term can be for any duration, even less than a year, or for many years, but it's clearly defined in the calendar.
Fixed start, fixed end.
Exactly. Once that date arrives, the lease automatically terminates without any further notice required. An estate from period to period, or periodic tenancy, is a leasehold estate that automatically renews for successive periods, for example, month to month or year to year, until either party gives proper notice to terminate.
This is like the typical month-to-month lease.
Very common for residential rentals after an initial fixed term expires, often becoming a month-to-month agreement. An estate at will describes a tenant's occupancy of a property with the landlord's consent, but without a fixed term or a regular rent payment schedule. It's often very flexible and can be terminated by either party with appropriate notice, typically 30 days.
Less formal, maybe?
Can be. Finally, an estate of sufferance occurs when a tenant continues to occupy a property beyond their lease term and without the landlord's consent.
A holdover tenant.
Exactly. This is often called a holdover situation, and the tenant is essentially trespassing, though the landlord may still accept rent temporarily while figuring out next steps. The core insight is that the type of lease determines its natural endpoint and the notice required for termination, impacting your flexibility as a tenant.
Commercial leases often have their own unique structures, especially when it comes to who pays for what or even how rent is calculated based on business performance. It's a whole different ballgame from residential leases, isn't it?
It absolutely is. If we connect this to the bigger picture, commercial leases are designed to align the financial interests of landlords and business tenants in various ways, often involving more complex rent calculations and expense allocations than residential leases.
So how does the rent work differently?
There are several types based on rent payment. A gross lease, also known as a full-service lease, is where the tenant pays a fixed monthly charge and the landlord is responsible for all operating expenses, such as property taxes, insurance, and maintenance.
Simple for the tenant, landlord handles the bills.
Right. A net lease requires the tenant to pay a base rent rate plus all or part of the property's operating expenses. This shifts some of the financial burden, like property taxes, to the tenant. A triple net lease is an even more comprehensive type of net lease, where the tenant pays a prorated portion of all operating expenses for the property, including taxes, insurance, and maintenance.
Triple net means the tenant pays almost everything except the mortgage.
Pretty much. This is common in single-tenant commercial buildings where the tenant truly takes on most of the property's ongoing costs. A percentage lease, common in retail settings, involves the tenant paying a base rent amount and a percentage of their business profits to the landlord.
So the landlord gets a cut if the store does well.
Exactly. This allows the landlord to share in the tenant's success. A variable lease is one where the rent increases over time, sometimes incrementally, as in a graduated lease. For example, rent increases 3% each year, or in relation to a specified factor or index through an escalator clause, for example, linked to the consumer price index.
Built-in rent increases. What about leasing just the bare land itself, separate from any buildings on it? That sounds like a very long-term commitment.
That's where ground leases or land leases come in. These involve the lease of bare, undeveloped land, typically for very long terms, often 50 years or more. The tenant constructs improvements, like buildings or shopping centers, on the land.
The tenant builds on the landlord's land.
Right. A key feature is that these improvements usually revert back to the original landowner upon the lease's expiration, making it a long-term investment for the landowner who gets the improved property back.
Wow. Okay.
In terms of tenant improvements, which are constructions or modifications made by the tenant to a leased space, these can be handled through improvement allowances, where the landlord gives cash to the tenant for the work, or turnkey projects, where the landlord handles the improvements completely, delivering a ready-to-use space to the tenant. The core insight is that commercial leases are far more tailored and complex than residential ones, often involving shared financial risk and reward.
What if a tenant needs to move out before their lease is up? There are specific ways to transfer their legal interest in a rental property to someone else, but they have different implications for liability.
That's a great question about flexibility within lease agreements and the original tenant's ongoing liability. The distinction between subleasing and assigning impacts who is directly responsible to the landlord. A sublease occurs when a tenant transfers part of their right of possession in a leased property to another person for a portion of the lease term.
So they rent out their rental, basically.
Kinda, yeah. Think of it like this. The original tenant still holds the master lease with the landlord, and the subleasee pays them. The original tenant, the sublessor, remains primarily responsible to the landlord for the rent and property condition.
Right.
Unless prohibited by the lease, subleasing is generally a tenant's legal right.
So if the subleasee stops paying, the original tenant is still on the hook. What about an assignment?
In an assignment, a tenant transfers the entire remaining balance of their lease to another person, permanently vacating the premises. In this case, the new tenant, the assignee, becomes directly responsible to the landlord for rent payments and property condition, though in some cases the original tenant may retain secondary liability, especially if the new tenant defaults.
So assignment shifts the main responsibility.
Generally, yes. The sources also mention a sandwich lease, which describes a situation where a lessee subleases a property, placing themselves sandwiched between the subleasee and the original lessor or owner. This original lessee is still responsible to the main landlord, while the subleasee pays them.
A lease within a lease.
Exactly. The core insight here is that subleasing leaves the original tenant primarily liable, while assignment shifts that liability more directly to the new tenant, but always check your lease. The lease document rules.
Leases also come with built-in protections and rules for both landlords and tenants, with specific laws governing fairness, especially here in California. It's not just about what's in the contract. There are broader legal frameworks.
That's a crucial point, and what's fascinating here are the robust state-level protections in California, even without adopting a national standard like the Uniform Residential Landlord and Tenant Act, URLTA. California has its own strong laws emphasizing fair practices and tenant rights. For instance, California anti-discrimination laws such as the Fair Employment and Housing Act, FEHA, protect tenants from discrimination based on various protected categories like race, gender, disability, sexual orientation, and source of income.
Important protections.
Very. The Unruh Civil Rights Act further extends these protections to all business establishments in California, including those providing housing services, ensuring equal treatment.
And what happens when things go wrong and a landlord needs to remove a tenant? It's not as simple as just telling them to leave, is it?
No, it's a strict legal process, and it's critical to understand the legal steps involved in evictions. The forced removal of a tenant due to a lease default. There are different types, and it's critical to understand the legal process. Actual eviction is the legal process by which a tenant is physically expelled from a property. This requires the landlord to give written notice, and often involves an unlawful detainer action in court to legally remove the tenant.
Gotta go through the courts.
Yes, it's a formal legal proceeding. In contrast, constructive eviction occurs when the landlord defaults on their obligations, for example, by failing to make required repairs that make the property uninhabitable, or by preventing the tenant's quiet enjoyment of the premises.
So the landlord makes it impossible to live there.
Exactly. In such cases, the tenant may be legally allowed to terminate the lease and move out because the landlord has, in effect, forced them out. It's crucial to know that self-help eviction, where a landlord takes matters into their own hands to force a tenant out, for example, changing locks, turning off utilities, threatening them, is illegal in California.
Cannot just lock someone out.
Absolutely not. You cannot simply lock a tenant out.
And finally, what are the rules for simply terminating a lease with notice in California, for instance, if a landlord just wants a tenant to move out when their month-to-month lease is up, or vice versa?
California has specific rules for lease termination with notice to ensure both parties have sufficient time to prepare and find new arrangements. If a tenant occupies a property for less than 1 year, the landlord must give 30 days advance written notice to terminate the lease.
30 days for under a year.
Right. However, if a tenant has lived in a rental property for more than 1 year, the landlord is required to provide 60 days advance notice.
60 days if they've been there longer, okay.
These rules are in place to provide stability and prevent abrupt displacements, reflecting California's focus on tenant protections. The core insight here is that while your lease defines your rights, California law adds significant protections, particularly around non-discrimination and proper eviction procedures. Eighth, understanding closing costs and financial calculations.
Once a property contract is signed, everything typically moves into escrow. What exactly does this formal process involve, and why is it so vital for safeguarding the entire transaction for both buyer and seller?
If we connect this to the bigger picture, escrow is the secure, neutral third-party process that safeguards the entire real estate transaction. It's like having a trusted referee holding on to all the crucial documents and money until every condition of the sale is met.
A neutral middleman.
Exactly. At its core, escrow is when an uninvolved, trusted party, the escrow holder, hold on to something of value like funds, legal instruments, or evidence of title until specific conditions are satisfied, at which point these items are then delivered to the appropriate party. There are two fundamental requirements to create a valid escrow for transferring property. First, a binding contract between the buyer and seller, and second, the conditional delivery of something of value to that neutral third party. Without both, it's not a true escrow.
So who can actually act as an escrow holder in California? Is it just specialized companies?
In California, you have two types of escrow holders. Licensed escrow companies, which are heavily regulated by the Department of Financial Protection and Innovation, and must meet specific requirements, like providing a surety bond, and controlled escrow companies, which are exempt from licensing.
Controlled means exempt.
Yes, exempt from the specific escrow licensing. This latter group includes banks, savings and loan associations, lawyers, and title companies. Interestingly, real estate brokers can act as escrow holders in specific limited circumstances.
The broker involved in the deal.
Right. They must be the listing or buyer broker for that particular transaction. They can't simply open an escrow business separate from their brokerage. Their escrow services cannot be their primary business or advertised separately, and they cannot form a company with other brokers solely for escrow services. The exemption applies only to the broker, not their supervised agents, and all escrow funds must be kept strictly segregated in a trust account.
Strict rules for brokers doing escrow.
Very strict. This limited capacity ensures that brokers primarily focus on their brokerage duties while providing a convenience in certain transactions.
And what exactly are the instructions given to this escrow holder? I imagine they're very detailed.
They are. The escrow instructions are detailed directions given to the escrow holder at the time escrow is opened. These instructions, signed by both buyer and seller, dictate precisely how the transaction should be carried out, everything from how taxes are prorated to who pays for specific fees.
The roadmap for the closing.
Exactly. Sometimes these instructions are part of the purchase contract itself, and sometimes they're on a separate form. If there's a conflict between what the instructions say and what the contract says, the most recent document takes precedence. Escrow instructions can be unilateral, given separately by each party, common in Northern California, or bilateral, given by both parties together, common in Southern California.
NorCal versus SoCal difference. Interesting.
Yeah, regional customs. If the buyer and seller cannot resolve conflicts in their escrow instructions, the escrow agent can file an interpleader action, suing both parties to force a resolution in court, essentially saying, I can't proceed until you two agree.
Escrow asks the judge to decide.
Basically, yes. The core insight here is that escrow is your impartial safeguard, ensuring no money or documents change hands until all conditions you specify are met.
Then comes the final hurdle that often catches people off guard. Closing costs. It's a complex ledger of debits and credits that can add up quickly, and it's often confusing who pays for what.
You're right, and this raises an important question about financial planning for a real estate transaction. While some costs are customary for either the buyer or the seller, many are negotiable, highlighting the importance of understanding each line item.
Okay, so what does the buyer usually pay for?
Buyers' typical closing costs often include appraisal fees required by lenders to assess property value, loan origination fees, what the lender charges for processing the loan, points, if chosen to lower the interest rate, as we discussed, the lender's title insurance policy, customary for buyers in CA, protecting the lender, recording fees, $75 in CA to officially record the deed, prepaid homeowner's insurance, often a year's premium, and prorated property taxes, or HOA fees, for the period the buyer will own the property.
Great list for the buyer. And what does the seller usually pay for in California?
Sellers' typical closing costs commonly involve the broker's commission, usually a negotiated percentage of the sales price, the largest cost for a seller.
The big one.
Usually. Also, the documentary transfer tax, 55 cents per $500 in CA, the satisfaction of any existing liens on the property, like paying off their mortgage, and the owner's title insurance policy, customary for sellers in CA, protecting the buyer. Many other fees, including the escrow fee itself and HOA transfer fees, can be negotiated between buyer and seller depending on local custom and market conditions.
So customary doesn't always mean required.
Exactly. It's all about negotiation and what's typical in your local market. At closing, the financial transactions are meticulously tracked as debits, sums of money owed, and credits, sums received. A crucial part of this process is proration.
Splitting the bills based on time.
Right. It's the act of dividing or allocating expenses like property taxes, insurance, or HOA fees between buyers and sellers based on the actual period of usage. For example, if property taxes are paid in advance for the year and you buy the house halfway through, the seller will get a credit for the portion of the taxes they've prepaid that you will use. This often uses a banker's year of 360 days for calculations, as specified in the contract.
Banker's year. Okay.
The net to seller is the amount of money a seller actually receives from a transaction, calculated by subtracting their total debits, like their loan balance and all their closing costs, from their total credits, primarily the purchase price. Finally, the entire process of verifying that the closing disclosure correctly assesses all these costs, ensuring accuracy for the final financial settlement, is known as reconciliation.
Making sure all the numbers add up.
Precisely. The core insight here is that closing costs are a detailed financial dance, and understanding each step can save you significant money and stress. 9. Preparing for the exam and the path forward.
Finally, our sources, being comprehensive study guides, offer some insights into the journey of becoming a real estate professional and how important a firm grasp of all these concepts is for true mastery, far beyond just passing a test. It really ties into why these foundational principles matter.
It absolutely does. What's truly fascinating here is the dedication required to master this field. The California licensing process itself is designed to ensure a strong foundational understanding of these principles, covering everything we've touched on today and more, really solidifying that knowledge.
So the state makes sure agents know this stuff.
They try. For instance, to get a California real estate salesperson license, an applicant must be at least 18 years old, meet residency and honesty requirements, and crucially, complete 135 hours of pre-licensing education. This includes mandatory courses like real estate principles and real estate practices.
A lot of coursework.
It is. After completing the education, they must pass a challenging 100-question state exam with at least 70% correct, find a sponsoring broker to work under, and undergo a background check. It's a thorough process designed to create knowledgeable professionals.
And the exam content itself directly reflects all the areas we've dived into today, underscoring their real-world importance for anyone stepping into this profession.
Precisely. The exam content outline categories, as detailed in the sources, align perfectly with our deep dive. They cover crucial areas like property ownership and land use controls, laws of agency and fiduciary duties, property valuation and financial analysis, financing, transfer of property, the practice of real estate and disclosures, and contracts.
All the things we've been talking about.
Exactly.
Exactly.
This structure reinforces that the knowledge we've unpacked today isn't just theoretical. It's the practical foundation for a successful and ethical real estate career. For you, the listener, it's also proof that the insights you've gained are the very same building blocks professionals rely on every single day.
We've covered a lot today, haven't we? We started by peeling back the layers of the real estate profession itself, moved into the diverse world of property ownership and how those rights are structured, navigated the complex terrain of encumbrances and lelands that can affect a title, then explored the vital agency relationships that define who represents whom.
Then the lending process, leaseholds.
Right. We then broke down the intricate lending process that secures most investments, looked at the world of leasehold interests, and finally, demystified the often confusing world of closing costs.
It's a vast and complex field, but one that is absolutely understandable once you break down these core components and understand their real-world implications. We hope that by exploring these topics, you feel better equipped to navigate the real estate world, whether as a participant or just a curious observer.
Whether you're thinking of buying your first home, selling an inherited property, or just want to be a more informed citizen in this crucial part of our economy, hopefully you now have a clearer, more confident picture of this intricate world. These aren't just dry facts. They're the building blocks of real-world transactions that affect us all.
As we wrap up this deep dive, consider this. How might understanding the nuances of lane priority, or the distinct types of deeds, or even the different levels of agency empower you in your next real estate interaction?
Yeah, how does this knowledge change how you approach things?
Perhaps it will transform you from just a participant into a truly informed and prepared player, ready to ask the right questions and make the best decisions for yourself.
Keep exploring, keep asking questions, and keep making those deep dives into the topics that matter most to you.